Hi, I'm Akshay Sehgal and I'm here to present my Critic 3 presentation, which is discrimination in employment on the grounds of sexual harassment. So my case is between Shelby and OPM versus Gagan Gill and Gilco Incorporation. So on May 2nd, 2011, the complainant was enlisted to file in as a sales rep and a supervisor at the Mobility retail location, possessed and worked by the respondents and situated on 17th Avenue, Calgary, Alberta, where the griever, Ms. Shelby N, filed a complaint that she was being bullied and sexually harassed at work by her manager, Mr. Gagan Gill. Complainant wants a financial compensation from the employer due to sexual harassment at workplace. Employer, in return, argued that he wanted to get a date book in which she recorded her hours worked, but she refused to give it to him. Ms. Shelby filed a complaint about her manager that she's been sexually harassed and bullied by him in many ways, such as Mr. Gill began to make sexually explicit comments to the complainant. The complainant alleges she was subjected to a series of harassing behaviors from Mr. Gill as a result of her sex and age, including the following unwelcome sexual conduct: a sexualized and demeaning work request, sexual comments, sexual request, and sexual touching. The only witness to these matters was individual respondent's wife, Jasmine Gill. The respondents did not call her to give evidence. In particular, the respondents did not call Jasmine Gill to dispute the complainant's evidence that on June 25, 2011, the complainant disclosed to Jasmine Gill all of the allegations of sexual conduct that form the basis of this complaint. The complainant gave clear and specific evidence consistent with the allegations in her complaint of sexual conduct to which she was exposed, both verbal and physically. The sexual conduct consisted of the following uninvited and unwelcome behavior: sexual comments, sexual touching, sexual requests, and so on, and deeming work requests that complainant walk up and down the street in the front of Mobility store. The conduct was both frequent and ongoing throughout the period of the complainant's employment with the respondents, as well on several occasions where the sexual conduct constituted as assault, it was severe enough to constitute sexual harassment based on sole occurrence. In this case, notification of the employer was not necessary, as there is no evidence the Mobility business had either a personal department or a harassment policy. Nevertheless, I find that notification was clearly given, as Mr. Gill was both the responsible employer and the harasser. He was clearly aware of the conduct that was taking place and of the objections to that conduct expressed by the complainant. Some of the remedies which the Commission gave, given the finding that the complainant suffered the discriminatory practices of sexual harassment under Section 14 and adverse differentiation in the course of her employment based on sex under subsection 7b, the complainant may be enlisted to compensation. The first claim is for amounts owing to her as unpaid income during her period of employment with the respondents. These amounts are not eligible for compensation, as on the facts it appears that all amounts owing to the complainant were paid to her by the time she left the respondent's employment. Insufficient evidence was led to support any further claims for unpaid income during her employment. The complainant did give evidence that she had found the experience with Mr. Gill very difficult and had been unable to return to work until she began taking antidepressants in August 2011. In view of the above evidence and the evidence presented indicating her previous earnings the complainant's compensation for lost wages in accordance with subsection 53(2)(c) of the CHRA shall therefore be restricted to the 1 month period immediately following the end of her employ with the respondents. The complainant is therefore entitled to compensation from the respondents for this 1 month period in amount of $1,788. So, the conclusion and decision by the court was, having found that the complainant's allegations against the respondents have been sustained in part in accordance with subsection 7b and 14 of the CHRA, the tribunal orders pursuant to section 53 that the respondent shall pay the complainant $1,788 as compensation for lost wages. The respondent shall pay the complainant $7,500 as compensation for pain and suffering. The respondent shall pay to complainant $12,000 amount as compensation for willful and reckless conduct. Thank you.